नमस्कार। महाराष्ट्र के राजनीतिक इतिहास और दल बदल विरोधी कानून को लेकर आज देश की सर्वोच्च अदालत में एक बेहद गंभीर और नया मोड़ आया है। आज माननीय सुप्रीम कोर्ट की 3 सदस्यीय पीठ के सामने शिवसेना विवाद के कानूनी पहलुओं पर गहन चर्चा हुई। माननीय अदालत के भीतर आज उद्धव ठाकरे गुट का पक्ष रखते हुए वरिष्ठ अधिवक्ता कपिल सिब्बल ने दलील दी कि चुनिंदा जनप्रतिनिधियों के अलग होने मात्र से पूरी मूल पार्टी का अस्तित्व नहीं बदला जा सकता। उन्होंने तर्क दिया कि एक राजनीतिक दल का असली आधार उसके जमीनी कार्यकर्ता और प्राथमिक सदस्य होते हैं। इस पर माननीय न्यायाधीशों ने भी एक बेहद दूरगामी टिप्पणी की है। अदालत ने संकेत दिया है कि न्यायपालिका को यह बारीकी से देखना होगा कि क्या विधायकों की यह आपसी फूट सिर्फ सदन तक सीमित थी या फिर यह विभाजन पार्टी के निचले सांगठनिक ढांचे तक भी पहुंचा है। एक महत्वपूर्ण सूचना, यह वीडियो केवल शैक्षणिक और सूचनात्मक उद्देश्यों के लिए बनाया गया है और इसका मकसद किसी भी चल रही अदालती प्रक्रिया पर व्यक्तिगत टिप्पणी करना नहीं है। आइए आज की इस पूरी अदालती कार्यवाही देखते हैं।
is being referred to by the petitioner and the respondent as the apex body with a numerical universe of 13. As mentioned above, the Rashtriya Karkani is a body which is elected by Pratinidhi Sabha, which itself is a largely appointed body. Further, the 2018 constitution of the party states that the strength of Rashtriya Karkani shall be 13 members. However, as per the letter of 27-2, by way of which details of the last organizational elections were communicated, names of only 9 elected Shiv Sena leaders were mentioned and details of the other 4 positions in the Rashtriya Karkani were not mentioned therein. 4 Shiv Sena leaders were appointed by the Shiv Sena Paksh Pramukh, who are required to be elected by the Pratinidhi Sabha during the next organizational elections to become members of the Rashtriya Karkani as mentioned in the party constitution. The credibility of the numerical count in Rashtriya Karkani is being eroded by the smallness of the counting universe. What does that mean, Malad? Being 13. So now the Election Commission wants that the Rashtriya Karnagani should have 20 or 25. What is the logic for this? Being 13 is also being denuded by an opaqueness in the description of its membership and it being situated in a non-democratic system. I just wanted to, Mullah, indicate to your Lordship that's how the Election Commission is dealing with this matter. Now, Mullah, I go back to what the judgment that the Election Commission relied upon, which is dispute number 1 of 1994, judgment of session, Mullah. Your Lordships will find that in the supplementary judgment compilation, page 26. Page 26. This is the Janta Dal dispute between George Fernandez and S.R. Bomai.
No,
page 26. Compilation at page 26. Supplementary judgment compilation at page 26. That's correct. Which is, Milad, relied upon by the Election Commission as conclusive.
Para 106.
In para 106, Milad. Now, Milad, just see, come straight away to paragraph 28 at page 32. The applicant group, Milad, in para 28 is George Fernandez.
Claims that.
Yes. The applicant group claims that the Janata Dal had become defunct and its functioning paralyzed, and that his group has revitalized or attempted to revitalize it by bringing its function according to the provisions of the party constitution. I need not go into the internal inter-party squabbles, but the records adduced by the applicant group itself do not substantiate its claims. The 90 group shows at least the following 4 things. A national executive of the party was existing on that day, and the applicant group has itself accepted the fact of his existence up to that day. 2. George Fernandez was himself a member of the national executive and neither he nor any of the other 8 members of that committee whose support is claimed by the applicant group questioned the existence of the executive committee at that meeting on the ground that it was not a validly constituted body. 3. This is like Eknath Shinde Malas. He was participating in everything. 3. Shri Bomai was being accepted as the party president, just as Malas in our case, up to the date of that meeting, and no objection was being raised to his occupying that office by anyone, including those who are now representing the applicant group. 4. Shri Bomai did not cease to be the party president or vacate that office at that meeting. Nothing has been brought on record to show that any such objections had been raised in any earlier meetings. Therefore, it is too late in the day for the applicant group to contend now that there is no validly elected president of the party and that there was no validly constituted bodies since the beginning. More so, in view of the fact that they themselves had acquiesced in those arrangements and were party to those arrangements at least up to 14th February 1994. Squarely, Malas covers our case. Squarely. And the Election Commission relied upon it against us. Then, the subsequent events, as brought on record, also do not substantiate the claims of the applicant group that they alone have been acting in accordance with the party constitution. It is nowhere stated in any of its pleadings, nor disclosed in the oral submissions of the learned counsel for the applicant group as to when and where was George Fernandez elected or appointed as the party president, or by whom he was so elected or appointed. Further, nothing has been brought on record to show as to who convened the so-called National Convention of the Janata Dal on 1908 in Delhi. When such convention was called, who were the persons to whom invitations were sent as party delegates, except for a list showing the names of 39 persons belonging to Tamil Nadu, and who among them attended that convention. No notice for such convention or agenda for it has been brought on record. Similarly, the claims of state conventions and reorganization of state units are also bereft of material particulars.
Shinde set up, which is completely there.
And whereas he set up a Rashtriya Karkani on his own. No notice, no nothing. This is all. Anyway, thus on these assertions and evidence adduced in support thereof, the claim of the applicant group as being the Janata Dal cannot be accepted. Now, let us kindly come to 32. Learned counsel for the applicant group is right in his contention that while applying the test of majority, the Commission has to see the relative majority of the rival sections or groups in both the wings of the party, namely legislature wing and organizational wing. In support of the respective claims of the majority, the two rival groups in the present case have filed the following affidavits in respect of the members forming the legislature wing of the Janata Party. So, either we don't have to go into that. Just let's skip that. Then, let's kindly see para 36. Insofar as the application of test of majority of the organizational wing of the party is concerned, it is true that it is the primary members who constitute the party. But it is also equally true that it is well nigh impossible to ascertain the relevant strength of the primary members whose numbers may run into lakhs in the case of a national party, supporting one or the other rival factions or groups of the party in the case of a split. Therefore, the Commission has been applying this test of majority in respect of the bodies, committees forming the organizational wing of the party at the national or state levels. In several cases, even an exercise of such limited nature has resulted in a quagmire. The same consideration will weigh while considering the relative claims of both the groups in the organizational wing of the Janata Dal before the emergence of these two groups in June 94. This is important. Of the Janata Dal before the emergence of these two groups in 1994. And whereas I will respond to what my Lord Justice Bakshi said there, that we have to look at the unfolding of events. Whereas that test is in fact rejected. And I will demonstrate that presently. Any later developments leading to the constitution or reconstitution of any committees, bodies at the various levels by the two rival groups may not lead us anywhere. Then let's kindly come straight away to para 40. Having regard to the above, I am unable to accept the claim of the applicant group that it is the Janata Dal and is entitled to use its reserved symbol, chakra.
The decision is based on organizational
So
majority also.
So the decision is based on organizational majority also in the case. So, Malas, the Learned Counsel for the applicant group has made an alternative prayer that if the party's symbol chakra was not allowed to be used by the applicant group, it should not be allowed to be used by the opposite group as well, as it would confuse the electorate. I'm not able to persuade myself to agree to this alternative prayer of the applicant group either. The general elections to the legislative assemblies of 10 states are due to be held shortly. Of these 10 states, the election would, Malas, let it go. Let's not leave that. Let's leave that out. Kindly come. Malas, now para 40. So, Malas, he's decided the dispute. Here, Malas, he rejects the applicant's claim with his George Fernandez claim, right? On all counts, and says Bomai is legitimately elected and he continues to be the president. Now he says, before I part, and this is the part that the election commission relies upon in para 106. Says, before I part with this case, I would be failing in my duty if I do not highlight the sorry state of affairs prevailing in almost all political parties in the country, whether recognized national or state parties or registered unrecognized parties. Ad hocism seems to be the order of the day in the functioning of almost all political parties. Maybe there are a few exceptions to this. In my stint as Chief Election Commissioner during the last nearly 4 years, I have dealt with a number of cases of disputes arising at the national and state parties. I have yet to come across any party whose affairs are being run in accordance with the provisions of the Constitution or rules and regulations. As will be observed from the present case itself, the party was formed in 88 by an order dated 16/4/91. It had held that the party, I had held that the party was formed by the joining of some leaders and of office bearers of the Janata Party and Lok Dal in their individual capacities, and not by the formal merger of those two parties, as was claimed by the Janata Dal. Some committees of the party so formed were constituted at the national and state levels on ad hoc basis, pending regular constitution thereof in accordance with the party constitution. The state of affairs as brought out by the Learned Counsel for the applicant group, to which a detailed reference has been made in the earlier paragraphs, make a shocking revelation that such ad hoc arrangements still continue even after a lapse of nearly 5 years. The party has not yet regularly constituted even its national council, which, as per the revisions of the party constitution, is the highest deliberative body to run affairs. The state of affairs in other political parties also seems to be no better. There are political parties functioning at the national level for several decades and recognized by the Commission as such. No organizational elections have been held for very long years, even more than 10 years in some cases. Though their constitutions provide for periodic elections at all levels at regular intervals or 2-3 years, such organizations have not been held as and when due. Let's skip this, then skip it, and then kindly come straight away to para 50. Sorry, 48 first. 48 is what he relies upon. The Commission had observed in its order dated so-and-so in the case of dispute in the Indian National Congress that a group or section which wants to form a rival group or section within a party must exhaust all the remedies available to it under the constitution of the party to assert its majority and should come to the Commission if the other group has frustrated its efforts whimsically or capriciously and not in accordance with the party constitution or democratic norms. In almost all the cases of disputes in political parties with which I had occasion to deal, allegations have been made that the disputes had arisen or splits occasioned due to the arbitrary or capricious acts of certain office bearers who were not allowing the will of the majority to prevail. But in all such cases, what the Commission was confronted with was some office bearers occupying or sticking to their offices by the manipulative tactics of postponing or not holding altogether the organizational elections in the party, and with some ad hoc committees or bodies constituted of some handful of nominated members, chosen at the whim and fancy of the leaders at the top. That's not the case here, and he relies upon it.
We are not a case of ad hoc bodies.
We are not an ad hoc body. Our elections have been held. He has accepted it. He was appointed under the Constitution. He never raised an objection. Years passed. And suddenly at the final stage of the arguments was the election commission, he talks over 1999 constitution, and suddenly he discovers that our constitution was unconstitutional or undemocratic.
But these paragraph 44 onwards,
Yes.
they are not concerning Janta Dal,
No, this is just a
general direction.
general term. And ultimately, you know what the session says? I will issue a notice to all parties to deregister them. So, Malad, he realizes that even if you're undemocratic, I can't do anything else except deregister. That's the point, Malad, that I was going to come to.
That is a paragraph 52.
Sorry?
52.
Yes.
Paragraph 52, he gives the note.
Yes.
Paragraph 49 opening lines are also.
Yes, he relies on para 49 also.
4 lines of 48 also.
Correct, Malad. Confronted with such, the commission finds itself in a helpless situation to grant relief to those who approach it, seeking protection against the tyranny of the privileged few, who have been treating the political parties headed by them as their fiefdom. So, Malad, he says, yes, I recognize that, but what can I do?
No,
And
because not a man who will feel helpless. That's why
Malad.
49 opening line.
Your Lordship is right. Your Lordship is right. It is true, I had the great pleasure of sort of.
Call them suo moto or you call them inherent, but he has done something.
Oh, yes, but he was a man who believed in principles and acted upon them. It is true that while para 50, while deciding a dispute in the recognized political party under para 15, the commission on the facts of circumstances of the case may decide that none of the rival sections or groups claiming to be that party is that party. During the course of the hearing of the present case, a specific question was put to the learned. During the course of the hearing, Malad, a specific question was put to learned counsel for the opposite group as to why the commission may not take the view on the facts of the circumstances of the case where the party affairs were apparently being carried on by the Janta Dal on ad hoc basis, that neither of the two rival groups before it is the Janta Dal.
Such a notice was given in the first.
In fairness to the learned counsel did concede that the various office bearers and governing bodies of the party had not been elected or constituted in accordance with the party constitution, but urged the commission not to take such a view, as that would be unprecedented and without any warning beforehand from the commission in such an important aspect affecting the very survival of the party. I have desisted from taking such a view in the present case because of two considerations. Firstly, I see force in the submission of learned counsel that the commission should not take such a position without prior notice to the political parties. So, Malad, this judgment is in our favor. And yet the commission has done all this without prior notice to us, come to these conclusions without prior notice to us, and benefited one side, Malad, who is also functioning under the same constitution, admits that he was appointed under the same constitution, and Malad benefits one party. Prior notice to the political parties and putting them on the alert that such a consequence will also follow if they do not constitute their governing bodies and elect their office bearers at various levels at regular prescribed intervals as provided in the party constitution and in accordance with those provisions that run their affairs on ad hoc basis indefinitely, whereby the members of the party are denied the opportunity of having an effective say in its functioning on democratic norms reflecting the will of the majority in a true sense. Secondly, the commission refrains from depriving a recognized national party of the use of its reserved symbol just on the eve of the general elections to the 10 state legislative assemblies where it may be putting up its candidates. It may lead to a confusion amongst the electors. The commission is therefore by and through this order puts all political The commission, therefore, by and through this order, puts all political parties, specifically those recognized by it under symbols order, as national or state parties on prior notice and on the alert that they should constitute their various governing bodies committees and elect their office bearers at different levels in accordance with their own party constitutions and within a reasonable time, say the next 4 months, commencing from the date of this order. And they say in accordance with their own party constitutions. He is not talking about undemocratic.
Next line.
Order. Any dispute brought before the commission thereafter under para 15 of the symbols order may result in a declaration that none of the rival sections or groups is the recognized party, which it claims to be, should the commission observe that the organizational elections have not been conducted in accordance with the party constitution. Affairs of the party are being run on an ad hoc basis, and ad hoc arrangements are the order rather than the exceptions in its organizational setup. They could never give them the benefit. In appropriate cases, the Commission may also be obliged to take recourse to the action against the defaulting parties under para 16A of the symbols order, which is Mala's de-recognition. So, Mala's, this judgment in my favor is used against me to benefit a rival who has acted with me under the Constitution, accepts the Constitution. No notice to me on any, and this is not a judgment that the Constitution is undemocratic or any of that. I mean, what is this new principle that he finds that the Constitution is undemocratic? Even Session says you do your elections in accordance with the Constitution. And whether a Constitution is undemocratic or not can't be decided with the greatest respect by the Commission. Supposing somebody is thrown out, a member of the party or an executive is thrown out, and there is a procedure in the Constitution, he doesn't go to the Commission. He'll go to the civil court. And he will say, look, please direct them to follow the Constitution. The Commission, if he goes to the Commission, Commission will say, I'm not concerned with your internal matters. You have a grievance against him, you go to the civil court. So how does the Commission get the jurisdiction to decide this? And assuming for a minute, that he does have the jurisdiction, Commission has, the jurisdiction, the only, direction he can give is follow it. Change your Constitution, bring it in accordance. If I have a grievance against that, I come to this court. That he has no jurisdiction to say that.
He can't give the symbol.
He can't give the symbol to him. Now, before I go, further, your Lordships put a very, and I've been thinking about it, that we have to look at the evolving situation. Let's take a case of the paragraph 3rd of the 10th schedule, and I'm reminded of Rajinder Singh Rana. So, Lordships will remember, in that case, an application was filed with 13 members of the Legislative Assembly of the BSP, claiming that they had split. An application for filed for their disqualification. The Speaker kept it pending. The number that was required was 37, because 37 made 1/3. So yet another split took place. Again, the Speaker did not decide. When it reached 37, the Speaker recognized that now you are 1/3, so you're a separate group. And therefore, it's a defense, as your Lordship knows, under the old paragraph 3. Matter went to High Court. High Court decided against. Matter came to Supreme Court. Supreme Court categorically said, nothing that happens after the first action can ever be taken into account for the purposes of recognizing the split, because when 13 members claimed, the Speaker was obliged to decide whether that 13 constitutes 1/3 or not. And whether they should be disqualified or not. You can't have there's a particular expression he uses, snowballing of legislators to make up the 1/3. Because you do that, you are then intrinsically interpreting the 10th schedule against its intent. The purpose of the 10th schedule is to prevent defections, the sin of defection. The purport of the 10th schedule is not to grant legitimacy to the sin. So, brothers, the relevant date is the date when you go to the speaker or the date when you go to the commission. And the facts prevailing on that date, a day previous to that, are the relevant facts for you to decide whether there is a split. Because if you say, brothers, what happens is, let's take this case. Application is made, application not decided till now. So how many years passed? Speaker did not take action. Notice was issued in 2023. They replied to the notice in 2023. So you don't decide the matter. Allow circumstances to overtake us. Become the chief minister. Go to the commission first.
Sin, as you say,
Yes.
is a coterminous sin.
Yes.
It's not a sin akin to the Representation of People's Act of a corrupt practice,
Yes.
which has consequences of debarring someone from an election process for
That's right.
years or something.
That's right. Now this
That's
disqualification.
the constitutional scheme under the 10th.
Absolutely, I agree. But if he had been disqualified,
That is maybe a problem in the working out of the 10th schedule today.
No. I am saying,
we have a
Malad,
speaker, because this court, in its first decision in Ihoto Holo case,
yes.
says that the speaker cannot be directed by a queer teammate. In
That's
government.
correct. That's quatermate action only, Malad.
Cannot.
That's correct.
So you cannot direct the speaker to take a decision within a time frame.
No, but that's been now, Justice Nariman's judgment is to the contrary. Explains what TK make.
Refers this question because of Holo to a larger bench.
No, Malad.
Justice Nariman takes a different view.
Yes.
But in view of the observations in Kyoto Holocron, His Lordship refers it to a larger bench, saying that Rana and Holon requires to be reconciled.
But Malad, your lordships have now held that the speaker is the tribunal. So you can give directions. In Subhash Desai itself, Malad. So that issue is no longer.
That issue, let us not go into it because it's not relevant here.
Correct. I'm only saying that subsequent events have no relevance for the purposes of deciding whether you are.
Disqualification, yes.
Yes.
Disqualification, yes.
I'm talking
But
about.
symbols order,
Yes, I'll demonstrate that, Your Lordship.
because we don't know. That is why on the first day, when you said that these two are of same genre, we said yes, same genre, but not the same species.
I agree.
The disqualification comes to an end with the assembly, but a symbol survives so long as the political party survives. And here the tribunal has not, or the election commission has not held that there is no Shiv Sena. The tribunal, by assigning the symbol order to Mr. Shinde, recognizes Mr. Shinde's rival group as the Shiv Sena.
Malad, I don't dispute that, Malad.
Why we are saying
Yes.
the evolving question, therefore, survives with the party,
Correct.
whereas the freezing of facts, where disqualification occurs, is the day on which the application for disqualification is made. And that is where the freezing, as per Rana, events prior to disqualification
No.
will be the determining factor
That's on the split, Malad. That's only on the split.
on the split.
Yes, I'm not.
On
Yes.
the split.
Not on disqualification.
So when there is a split, because the defense is taken on the split,
No, but speaker can take into account subsequent facts also, Malad.
in fact, supporting the split or not supporting the split.
No. For disqualification. For this, not for supporting this, for disqualification.
Right.
Because disqualification is a defense, Malad. to the defense. So, Mullah, that doesn't apply.
Split is the defense to the disqualification.
Yes, yes.
And the split must occur the day on which the application for disqualification.
No, there's no such law, Mullah. With respect, I
To the claim of a split.
no, that's not necessarily. Split is completely different, Mullah. Disqualification is completely different, Mullah. We'll demonstrate that, Your Lordship. But apart from that, Mullah, let's take it, Mullah, that the split issue had been decided. Let's assume, Mullah, these 36, because we are in appeal in that matter, right, for disqualification. Supposing it is decided that, no, he couldn't have been claimed a party, it's covered by the Constitution bench. That he was not the party. 5 judges have said so. So, Mullah, he'd be disqualified. Now time has passed. So what happens now, Mullah? Where is the legislative party test then? Because he says he has 39 members of the legislature, therefore he is the symbol. Mullah, so how relevant is that test? Right, Mullah? So therefore this whole big thing becomes academic. The point I'm making to your lordships is it's a very dangerous proposition of law to say that after the petition is filed under paragraph 15, subsequent events not demonstrated on the day of the filing will demonstrate whether the party claiming the symbol has the right to get the symbol because of subsequent events. Then you are allowing the use of political power, the use of the fruits of, right, to garner support, and therefore, in a sense, encouraging defection. You send somebody a notice under the ED, you send somebody a CBI notice, he'll immediately come to you, whether he's a legislator or he's a member of the party. So you can't interpret the provisions of the Constitution to give encouragement to the very sin that the anti-defection law tried to prevent. That's my answer to my Lord, Mullah.
In the disqualification case, the test will be different.
The disqualification case, the test would be entirely different, Mullah.
Subsequent
Subsequent events will be taken into account for disqualification, not for the purposes of split. Here, Mullah, you are encouraging the person in power who happens to have become the chief minister, who otherwise should have been disqualified, to use the power enjoyed by him and the fruits of power, and Mullah garnered as much support as he wanted. Surely, Mullah, neither para 15 nor the 10th schedule, paragraph 3, should be interpreted in that fashion if we are going to uphold the rule of law in this country. Now, let's kindly come back to my written submissions. Kindly come to my written submissions, please. Paragraph. Upar abhi. Yes, the page 5 of my written submissions. Whereas the heading, the powers of the Election Commission under 29A, and the guidelines framed thereunder have no application to the dispute under paragraph 15.
Page 5, Mr.
Page 5 of my written submissions.
Para 15.
Para 15. Just above para, section 29A governs registration and deregistration. So I've already, Mullah, mentioned that.
You have already explained.
Yes, so I'm not going to read it. I'm just pointing out, Mullah, where I have
29A, then last
4, 5, and 9.
9. That you have already explained.
Yes. So I'm not going to, I just want to indicate, Mullah. So then, Mullah, then in the debate in Parliament, Mullah, that I was mentioning, you would find that at paragraph 16, what Somnath Chatterjee says. That's on the 6th of December, 19.
29A.
Yes.
Debate on 29A.
29A. Prior to its introduction, Mullah. Somnath Chatterjee, 14th December, says, so far as registration of political parties is concerned, it is amazing that a law is being enacted for which no purpose is mentioned Was they were saying that, look, enact a law, but if the party doesn't acting to the constitution, have consequences, which parliament did not agree to. Political parties will be registered, but what is the effect of registration? Nowhere it is said. What is the effect of non-registration? Nowhere it is said. So do we know? Do we not know if it is not registered, what are the consequences? Merely putting in some provisions will not help. Already there is a provision for registration relating to grant of symbols. That is already there. There is a principle of recognition by the Election Commission for the purpose of grant of symbols. Then what for this is being included in the law? Nobody knows. So he said symbols order will take care of it of 1968. Banatwala says there is a clause here, clause 6, about registration of political parties, but for what purpose? What are the consequences?
There was some
हाँ, इसके बाद ही चलेंगे, जजमेंट करेंगे ना. There is a clause here, clause 6, about registration of political parties. But for what purpose? What are the consequences? Sorry. Well, this is a seminal opportunity for your lordships to really lay down the law for this country, the future of our democracy. This is not how commissions or speakers should function in this country. If really, we want to adhere to the principles on which our constitution was founded. It's a very sad state of affairs across the board. What are the consequences of registration? Whichever party is in power ensures that the disqualification is not heard. I'm not on any part. Every party does the same.
Schedule probably with the passage of time, I think requires to be revisited.
Yes. And that part of the 5 judges' judgment which says the election commission will decide first is the most dangerous part. And I would request your lordships to refer it to
Speaker will decide.
7 judges.
Speaker will decide.
Speaker has to.
People whosoever may be, the adjudication should be by an independent tribunal.
Yes.
I'm not saying that judiciary alone is the only forum.
No, it is alone when this happens. It is alone when this happens.
Parliament can select. Parliament can.
Of course it can. But Parliament, any ruling party, whoever is in Parliament, will not allow this to happen. Because they benefit from it. So only your lordships can correct. I mean, ultimately, the burden of keeping our democracy alive is with you, not with us. We will disturb.
Mr. Sibal, it's a responsibility of various
it's a collective responsibility.
No, when I say burden, we know on the basis of how we have acted. Well, I'm not.
We are conscious of our role of preserving the constitution.
That's what I mean. I am blaming myself.
The constitution is lived by the people.
That's true.
People do not wish to live by the constitution, I don't think.
And now people are trying to live by it.
Let's not underestimate. Our other institutions are also quite committed.
Of course. Well, I'm saying that. But I'm just saying the way it has functioned over the last 20, 30, 40 years is a matter of great concern for all of us, Mullahs. And ultimately, the law has to be laid down by your lordships. The Parliament will pass laws and continue to pass laws, but the test, it will be tested here. And this is a great opportunity to preserve the values that we embraced. So, Mullahs, I must say that that has been, I must say that has been added over here with sweeping powers given to the election commissioner. I must therefore strongly protest against such a purposeless clause and sweeping powers being given to the election commissioner for no purpose whatsoever. This can only lead to various complications. And then, but your lordships may leave this, and then kindly come to 29A, which I have already done, so your lordships may not go into it.
The three eminent members which you have quoted, Mr. Sibal,
Yes.
at least as young lawyers, we used to recollect, and we still recollect that how regularly they would participate
Yes,
in this.
absolutely.
There was not hardly any subject on the earth
I
on which
agree.
they will not be well prepared and
I agree.
participate in very constructive
I agree.
discussion and debate.
I agree. I am on the firm belief that people should have two professions, because one neglects one's primary duty as a lawmaker.
There was not a single day when they
Yes, yes. Then let's combine. I've already made my submissions on all of this. Then kindly come to the first judgment, that is SS Para 21, SS Karana versus Election Commission. Supplementary judgment compilation, page 3. I'll just read the passage from here, but I'll just show the dispute. कैसे इसको करें?
Same compilation which had the Janata Dal.
The same compilation which had the Janata Dal Madad.
Yes.
Yeah, same compilation. Thin compilation.
Supplementary first.
Page of that compilation, page 2, Madad. Just a few facts and then I'll come to the relevant paragraph. Lordship has that? Page 2, paragraph 1, SS Karana, who claims to be an active Congress High worker for the last 4-5 years, has approached this court under 226 for issue of an appropriate writ restraining the President of the All India Congress Committee from nominating 2 members of the Congress Working Committee to the seats vacated by elected members in the Tripura session of AICC, as the same would be in contravention of the party's constitution. This was his claim. Now kindly come to what the court says in paragraph 6 at Placetum G, page 3. The entire argument by counsel for the petitioner was that under subsection 9, it is the duty of the Election Commission to see that a registered political party complies with its memorandum or rules and regulations. And if any political party does not conform to them, a writ would lie. A body has been registered. A reading of subsection 9 of that is 29A shows that after an association or body has been registered as a political party, any change in its name, head office, office bearer's address, or in any other material matter shall be communicated to the Commission without delay. This only shows that if there is any change in particulars which were contained in the application at the time of registration, as required under subsection 4, not 5 minutes, 4, that has to be intimated to the Election Commission for the facility of the political party, and there is no duty enjoined on the Election Commission. The duty is cast on the political party that if there is any change in the aforesaid particulars, the Election Commission may be informed immediately so that it may make correction in its record. And if there is any communication to be addressed, it may be addressed in the name of the correct person and at the correct address. The petitioner does not disclose as to what duty was enjoined upon the Commission, which it has failed to carry out. Means the Commission has no jurisdiction on these things. So, Malas, that's the first judgment that I wanted to point. Then, Malas, kindly straight away come to, now see Malas, paragraph 22. In the impugned judgment, para 22, page 8, the Election Commission has referred to the guidelines prescribed by the election, which don't apply to 2010 under 29A, and held that the amendment in the constitution of the party is the most critical material change which has required to be communicated. Where? It's not part of 29A, 4, 5, 9. The reliance placed by the Commission on the guidelines to hold the amendments to the Constitution required to be supplied by the party to the Commission is misplaced, since 29A itself demonstrates that only material changes under 4 have to be, party has to be informed. Moreover, a bare perusal of guidelines prescribed by the Commission would show that their application is only at the time when the political party is seeking registration. My Lord Justice Bagchi also mentioned that. The guidelines do not have any application after the political party has been registered. In any case, the said guidelines were introduced in the year 2010, by which Shiv Sena political party was already registered. But assuming whether there was any duty cast, the Election Commission should have told us.
But your argument is that in any case, alternatively, you complied with that.
Yes, yes,
You got 29A9,
yes,
where the address or the
All that
names
we've
or
done.
election.
yes.
So that you refer
We
to
all-
that letter of 4th April.
Exactly. But assuming, Malaj, somebody were to say, Commission were to say, bring your party in line with democratic principles, this is my suggestion. Well, for that, Malaj, there has to be a separate direction.
This applies to post registration of the political party, but only in the, for the information as enumerated in clause 9.
That's correct. That's correct. Now, Malaj, just to show, Malaj, because my Lord mentioned about material particulars, just can you give my Lord? On that, Malaj, the Minister of Law and Justice, Malaj, at the time of the debate, the question was asked, what does other particulars mean? Material particulars means. Just give it. 271. Just give it. 15 December 271. Yeah, just give these two. I'm sorry, Malaj, it was, I just got it, Malaj. I'll put it enough.
Your compilation of
Yeah.
statutes.
There is some publication.
No,
Lok Sabha debate. So, Malaj, just see Shankaranand's Malaj's response, because he happened to be the Minister for Law and Justice at that time. And just see from the top of page 271 what he says. Lordship has that?
Page 271.
Yes, the proposed clause 29A speaks of registration of political parties virtually taken from para 6 of the election symbols order, where the law presently stands. There are two other paragraphs in the same order which speak of kinds of parties, recognized, unrecognized, state and national, which elaborate in detail what is the state party and what is the national party, what is the recognized party and what is the non-recognized party. These two parts have not been incorporated in this bill. Therefore, half the law with respect to registration remains in this bill, and the other half of the law remains in the symbols order. To cure this anomaly, I sought to introduce my amendment, which is a lengthy amendment. Then, Malaj, next is skip this Brijmohan Mohanty's speech. The second paragraph in this speech, he says, another point about enrollment of a new member by the party. For enrollment of new members, there would be a memorandum or a regulation. Whenever new members are enrolled, they should swear allegiance to the Constitution. That's the point, Millers, as to why this was amended. Then comes to the second column. He says, first of all, take the amendment objection to subsection clause, which says, Commission may call for such other particulars as it may deem fit from the association of bodies. Sir, it is seen from this subclause that this subclause has been put in the bottom of the other subclauses, and the parties which want to be registered with the Election Commission are required to give reasons, information on the various subclauses. Then in the end, we have said that the Commission may call for such other particulars as it may deem fit from the association of bodies. I can assure the House that the Commission is not going to ask for particulars which the party might consider to be untoward, the particulars which are legitimate for the purpose of registration. This is the residuary general clause. As is usual, this general clause is put, and I do not think members should be chary about the clause because there is nothing of ending to it. So, this is the purpose. It has to be read in justum generis.
You just done generous, the same.
That's the point. That's right.
Just done.
That's right. That's right. Otherwise, Manoj, it can include the whole universe. It can be anything. And the obligation is on the party that the party doesn't know what is to be given and what is not to be given. So, Manoj, I go back to my submission, paragraph 26. Very interesting judgment, Manoj, of this court in 2002, 5 SCC 685. Your Lordships will find that in the original compilation of that. It starts at page 401. This is the compilation which has Subhash Desai, Manoj.
Page, Mr. Sibal?
401.
Election Commission itself focus in paragraph. Maybe.
Yeah, later, I know.
Paragraph 5.
Indian National Congress.
Power to deregister. Paragraph 5.
Let us kindly see paragraph 5 at page 407.
So Election Commission stands.
That's the Election Commission stand before this court.
You are on the convenience compilation?
No, judgment compilation.
No, the first.
The first one, Madam. Subhash Desai, which has all the judgments.
Correct. Yeah.
401 at 407, paragraph 5.
These projects ask the Election Commission to deregister parties that were functioning in Kerala.
The idea was, well, a claim had been made to deregister parties which are functioning in Kerala. Right? And so the commission takes a position. The Election Commission of India also filed its return and stated therein that it does not have power to deregister or cancel the registration of a political party under 29A. It was also stated by the Election Commission that similar matter arose before it in a petition filed by Arjun Singh and others seeking deregistration of the Bharatiya Janata Party as a political party and also freezing of its reserved symbol lotus. And the Election Commission of India, by its order dated that, rejected the petition after having found that it does not have the power under 29A to deregister a registered political party. It was also brought to the notice of the High Court that the decision of the Election Commission was also tested by filing an SLP before the Supreme Court, but the same was dismissed on 28/8. In that view of the matter, no direction can be issued by the High Court to the Election Commission of India to take any proceeding for deregistration of a registered political party for having violated constitutional provisions. There are two issues, Maharaj. You violate a constitutional provision, you can't deregister. If you violate the para 5, you can deregister. The oath. So even the power to deregister is limited. Because the purpose of bringing in 29A was to make sure that political parties take oath to the Constitution. If you violate constitutional provisions, you can't deregister. So somebody makes a speech, Maharaj, which is clearly a corrupt practice, Maharaj, you can't deregister. Or a speech which is clearly antithetical to our constitutional beliefs, you can't deregister. But if the party itself says we don't believe in the Constitution, you will be deregistered. So even the power to deregister is exceptional.
The 92 orders of the past session, which they are referring to in paragraph 5.
Yes. And Miller, they refer to Sessions order in paragraph 5, 28/8/92. Even Session dismissed it. This 92 order was by Session. Hmm.
31 first. This one.
No, that's all right. Then paragraph 31, Malas.
417. Use 417.
No, Malas, para 20, I'm sorry. For para 20 at 414. Yeah, it's on the quasi-judicial part. Para 20 at 414. On the argument of parties, I'm sorry, Malas, you also have that?
Yes.
On the argument of parties, the question that arises for our consideration is whether the Election Commission, in exercise of its powers under 29A, acts administratively or quasi-judicially. We shall first advert to the argument raised by the learned counsel for the respondent, to the effect that in the absence of any list or contest between two contending parties before the Commission under 29A, the function discharged by it is administrative in nature and not quasi-judicial. There was no list between us, Mullahs, as far as this constitution was concerned. The dictionary meaning of the word quasi is not exactly, and is just in between judicial and administrative function. It is true, in many cases, the statutory authorities were held to be quasi-judicial authorities, and decisions rendered by them were regarded as quasi-judicial, where there was contest between the two contending parties, and the statutory authority was required to adjudicate upon the rights of parties. In Cooper versus so-and-so, definition of, let's leave that out. But so ultimately, the court says it's not quasi-judicial, it's purely administrative. Then para 21. This is another important paragraph. But there are cases where there is no list or two contending parties before the statutory authority, yet such a statutory authority has been held to be quasi-judicial and decision rendered by as a quasi-judicial decision when such a statutory authority is required to act judicially. Then, whereas they refer to one other judgment, let's leave that out. We don't want to go into all this. Then come to paragraph 30. Then the court analyzes section 29A and continues to do that. We'll skip that, Mullahs, goes to various judgments, and then comes straight away 31, 41, 31. 31, yes, 31, 32, and 33 at page 417. From the aforesaid provisions, it is manifest that the Constitution is required to consider the matter to give opportunity to the representative of the political party, and after making inquiry and further inquiry, arrive at a decision whether to register a political party or not. In view of the requirement of law that the Commission is to give decision only after making an inquiry, wherein an opportunity of hearing is to be given to the representatives of the party, we're of the view that the Election Commission under 29A is required to act judicially, and in that view of the matter, the Commission is, or the act of the Commission is quasi-judicial. This matter may be examined from another angle. If the directions of the High Court for considering the complaint of the respondent, the sum of the appellant political parties are not functioning in accordance with the provisions of 29A, is to be implemented. The result will be that a detailed inquiry has to be conducted where evidence may have to be adduced to substantiate or deny the allegations against the parties. Thus, a list would arise. Then there would be two contending parties opposed to each other, and the Commission has to decide the matter of deregistration of a political party. In such a situation, the proceedings before the Commission would partake the character of quasi-judicial proceedings. Deregistration of a political party is a serious matter as it involves divesting of the party of the statutory status of a registered political party. We are therefore of the view that unless there is an express power of review conferred upon the Commission has no power to entertain. No power to entertain or inquire into the complaint for deregistering a political party for having violated constitutional provisions. However, there are three exceptions. Now, this is important. Where the Commission can review its order registering a political party. One is where a political party obtained its registration by playing fraud on the Commission. Secondly, it arises out of subsection 9 of 29A of the Act, and thirdly, any like ground where no inquiry is called for on the part of the Election Commission, for example, where the political party concerned is declared unlawful by the central government under the provisions of the UAPA or any other similar law. Coming to the first question, it is almost settled law that fraud vitiates, so that's not an issue. Then 35, coming to the second exception, is where a political party changes its nomenclature or association rules and regulations, abrogating the provisions therein, conforming to the provisions of 29A5, or intimating the Commission that it has ceased to have faith and allegiance to the Constitution of India, or to the principles of socialism, secularism, and democracy, or it would not uphold the sovereignty, unity, and integrity of India so as to comply with the provisions of 29A5. In such cases, the very substratum which the party obtained registration is knocked off, and the Commission, in its ancillary power, can undo the registration of a political party. Similar case in respect of any like ground where no inquiry is called for on the part of the Commission. In this category of cases, the case would be where a registered political party is declared unlawful under the central government under the provisions of UAPA or any other similar law. In such cases, power of the Commission to cancel the registration of a political party is sustainable on the settled legal principle that when a statutory authority is conferred with a power, all incidental and ancillary powers to effectuate such power are within the conferment of power, although not expressly conferred. But such an ancillary and incidental power of the Commission is not an implied power of revocation. That's not an implied power of revocation. The ancillary and incidental power of the Commission cannot be extended to a case where a registered political party admits that it has faith in the Constitution and principles of socialism, secularism, and democracy, but some people repudiate such admission and call for an inquiry by the Election Commission, reason being an incident and ancillary power of the statutory authority is not the substitute of an express power of review. And then, Mullahs, 41, to sum up, and that's the conclusion, Mullahs.
So you are basically relying on paragraph 35.
Yes, yes. So if you say that I'm undemocratic, this is not the remedy. And once you say that you are under the 2018 Constitution, you can't raise this objection. The Commission can't do anything because they issue no notice to me, even if they had the power. And then they give the benefit and give it to my symbol to the other party in the same dispute. So, Namalas, then I'll quickly, that's all right. Then para 38 also, Parliament has chosen not to confer any express power to register. That's in para 38. Namalas, kindly come, that's all right. Let's not be quick about it. We all need to finish. Then, para for 32 of my submissions. There's another judgment of the Delhi High Court this time. Gaurav Yadav versus Govind Yadav versus Union of India. Your lordships will find that.
The very next in compilation.
Yes, yes.
Same compilation.
Same compilation. Yes. It starts at page
422, Mr. Subal.
420. It's before that. 422 it starts, Mullahs. Para 2, Mullahs, just give your lordships as to what the issue is. Para 2 at page 422. The appellant petitioner has instituted the aforesaid petition before the learned single judge, primarily seeking a declaration that the communication dated so-and-so made by a political party, namely Janata Dal United, under 29A of the Representation of People's Act, are null and void for the reason that such communications contain names of office bearers of JDU on the basis of alleged fraudulent conducted elections in contravention of the Constitution and rules governing the JDU. This was the issue. Now see the reply of the EC, para 6, Mullahs. Subparagraph B. Reply of the EC is, as per the assertion of the appellant petitioner, he was elected as the state president of Madhya Pradesh unit and that he has occupied various significant positions in the said political party. By communication dated so and so, ECI was intimated that respondent 3 was elected as president in an organizational election held by the commission of the said political party. The appellant petitioner disputed the election of respondent 3 as the president of JDU on the count that the same was not in accordance with the constitution of the JDU. Accordingly, he is said to have submitted a representation on 4/11/16 along with 3 other individuals, wherein he raised certain objections and pointed out alleged illegalities in the organizational elections. Another complaint, so many of these complaints went on.
Now see ENF.
Now see ENF. The ECI, via its communication, intimated the appellant petitioner and also Mr. Thakur Balbir Singh that forum for raising such disputes regarding internal party elections has been provided in clause 17 of the Constitution, and that there is also a provision for appeal in respect of disciplinary actions. The Commission also stated that if the appellant petitioner so desired, he may avail the remedy under the said provisions available in the party constitution, and that expulsion from the membership are civil matters, and therefore if the appellant petitioner so desires, he may approach the appropriate courts in this regard for redressal of grievances. Then let us kindly come to paragraph 9. This is what the court says is the question. Submission made on behalf of appellant petitioner hinges around the interpretation regarding nature, scope, and extent of powers of ECI under the provisions contained in 29A9. It has thus been contended by learned counsel representing the appellant petitioner that it is the duty of the Commission to conduct an inquiry if the information regarding the election of any other material matter communicated to the ECI is objected to. The submission is that taking any information on record. So when I send Malad that he has been elected, he is the Paksh Pramukh, he has been that. He says the submission is that taking any information on record under 29A9 intrinsically casts a duty on the ECI to ensure the validity and authenticity of such information. On the strength of the aforesaid contentions, it has been argued by learned counsel for the appellant petitioner that learned single judge has erred in law in not correctly appreciating the scope and extent of the powers and duties of ECI under 29A9, and accordingly, the judgment rendered by the learned single judge, which is under challenge herein, is flawed and therefore deserves to be set aside. Now, let us kindly see para 11. Opposing the instant appeal, learned counsel representing ECI has vehemently argued, that's the Election Commission of India, that the submissions made on behalf of the appellant petitioner are absolutely misconceived, having regard to the provisions of 29A9 of the Act. He has also argued that the judgment of the learned single judge, which is under challenge, correctly appreciates the ambit of the section, which does not vest any power or authority or jurisdiction in the Commission to entertain any dispute in relation to elections of office bearers of a political party. And as a matter of fact, in nature and in case, the authority available to ECI under the said provisions is only ministerial in nature, and in case any information has been taken on record under 29A9 by the ECI, and if anyone disputes the same, such a person has to establish his rights by instituting appropriate proceedings before civil court. This is ECI's own position, Malad. Then, Malad, having regard to the pleadings, that is Malad paragraph 15. Now, Malad, let's skip the rest. Now, kindly come to
21, I think, 21 paragraph.
That's correct. 21.
Even 29.
That's right. Thus, what has been provided by the legislature while enacting so and so is that the case of any alteration or change in name office bearer, such an alteration or change needs to be communicated. A plain reading of 29A would suggest that the legislative scheme provided therein is for the purpose of registration of an association or a body, and is thus to be construed within the broader legislative scheme of 29A. Since 29A provides for registration of an association, we are of the unambiguous view that requirement of submission of information relating to change in name is for the purposes of maintaining proper and up-to-date record. And then, Malas, kindly see para 23, and then I'm done, Malas. If the submission made on behalf of the appellant are analyzed in the context of the scheme of 29 and the purpose of its enactment, what we find is that we are called upon by the appellant petitioner to construe subsection 9 by supplying certain words and phrases which are otherwise absent in the said provision. This observation is based on the submission urged by learned counsel for the appellant petitioner that once the information as contemplated is furnished, it can be taken on record only on an inquiry into the authenticity and correctness of such information. In a situation where objection to such information is raised, the insistence on the part of the appellant petitioner is to the effect that some kind of adjudicatory process needs to be adopted by the ECI in such a situation to determine as to whether the information submitted to it is correct. And then the judge holds there is no such obligation, brothers. And that your lordships will find at
24 and then 33.
24 and then 33 onwards, brothers. 33 says, learned counsel for the appellant has attempted to interpret 9 of subsection 29 in a manner which would empower the EC to travel into the kind of adjudicatory process in case there is an objection to the information. He says there is no such thing. So, Mullahs, then in what ambit will this power of the commission fall in the context of 29A? For the commission to say, look, you may have agreed to your constitution, I don't care, it's undemocratic, is authoritative, and therefore I won't look at it. So the only thing, therefore I will not look at the organizational structure because it is inconsistent with the 1999 constitution. And therefore I will not look at any of that. Since you have the legislative majority, I give you the symbol.
In the written submission, now we can just leave the passages.
Now, Malas, I'll just go to the written submissions because I will finish today, Malas, on this issue. As I promised. Para 34, Malas, of my written submissions.
Of your submission.
Written submissions, page 11, Malas. There's another judgment cited, Malas. This is again a Delhi High Court judgment, Hansraj Jain, but I just read the underlying portion, Malas, of the judgment.
Para 35.
No, para 18 first. 18, part of para 35, page 11. The particulars required by 29A to be furnished by a political party seeking registration are only for the purpose of identifying thereof and not for any other reason. The provisions of 29A are not intended to be a deterrent to registration of political parties, though the said guidelines inter alia require that there should be a specific provision in the rules constitution of the association or body of persons seeking registration as political party regarding internal democracy in the party, organizational elections at different levels, mode of such elections, but there is nothing either in 29A or in the said guidelines requiring an inquiry to be conducted into the fairness and validity of the elections held by for the post of office bearers of political parties.
SLP against this was dismissed.
SLP against this was dismissed, Mullahs. And then the next judgment is a Madras High Court judgment, which is at para 37, page 13. I'll read the underlined portion. All these judgments are there, Mullahs, but I don't want to waste your lordship's time. All that section 29A9 contemplates that is after an association or body has been registered as a political party, any change in its name, head office, office bearer's address shall be communicated to the Commission without any delay. Such power does not confer any corresponding duty on the Commission to enter into the internal elections of a political party, or for that matter, the constitutional structure of the party. That's why I talked about voluntary Mullahs association 19(1)(c) and the so Mullahs, this then we have. Then Mullahs kindly see, yes, para 47.
There is para 40.
Para 40? Okay. Yes, Mullahs, there's the para 38. There's another petition. Sheikh Shahrukh versus Youth Congress. MP High Court, Mullahs.
The guidelines cannot be used to question the recall election.
It says that the guidelines cannot be used, Mullahs, to question the election in a political party. Well, skip 8 minutes. 40 now.
Has been interpreted.
That's correct. That's correct. Para 40 minutes. Under para 15 of the symbols order, the commission is required to decide which of the two rival factions of a recognized political party are entitled to the symbol of that party. Thus, by definition, the dispute under para 15 is between rival factions of a single recognized party. And whereas ultimately the Election Commission says because the legislative party is the party and it has numerical superiority, therefore it happens to be the party and therefore factions within the party. But then what happens is, Millers, when this happens, because as I told you, Lordships, 30th he becomes the chief minister. 19th of July, 30th, 19th July, by that time nothing happened. But there was a tidal wave after that, Millers, because he continued to be in power. He's still in power. Anyway, then para 41. In such a dispute, both factions necessarily belong to that party and are consequently governed by the constitution of that party. Therefore, the commission cannot in law conduct an inquiry or whether the political party's constitution is democratic or otherwise invalid. If the commission conducts such an inquiry and comes to the finding that the party constitution is undemocratic or otherwise invalid, consequence of such a finding can never be for the benefit of one faction over another, since both factions are governed by the same constitution. It is for this reason that it is futile in a dispute under para 15 to consider the validity of the political party's constitution. And then, Miller, there are also judgments which say that if both parties accept the constitution, then, Miller, they can't challenge any action. Para 44, Miller. In fact, Shri Shinde was appointed as Shiv Sena leader by Paksh Pramukh. I've already told my lord is aware of. All right. In exercise of the same power that is described by the commission as authoritarian, the group of MLAs led by Shinde were set up for the Maharashtra Assembly in 2019 by party leadership constituted under 2018. Eknath Shinde had willingly accepted the benefits of the 2018 constitution, become a member of the Rashtriya Karkarani, appointment as Shiv Sena leader, successfully contesting the 2019 assembly elections on the Shiv Sena party ticket given by him by party leadership, served as minister in the coalition government in Maharashtra from 19 to 22, coalition having been formed by the same party leadership. And four, before the election commission, Shinde laid claim to the party under para 15 based on legislative majority derived from the same party leadership. In such circumstances, the commission, while adjudicating between two rival factions of the same party, could not have disregarded one faction by calling the party constitution undemocratic and given the benefit of the rival faction, which also owed its origin to the same constitution. Then, Millers, this is that Chotu Bhai Vasawa judgment.
By the election commission.
Yes.
Para 15.
Para 15, Millers. It's a para 15 order. Accordingly, so-and-so, para 29, Millers. So-and-so, counsel for petitioner cannot question the validity of the organizational elections held by the party in October at the behest of a petitioner, Chotu Bhai, who now claims to have been elected as the president of the party at yet another election stated to have been held in August-September by the petitioner group by nullifying the earlier elections. In any event, as has already been communicated by the commission in its letters dated so-and-so, any question relating to the validity of organizational elections of the party can be raised either before the party forum as provided by the party constitution or before the court of competent jurisdiction. Now, the Arjun Singh decision is also very important. That's at page Last line is all these disputes are of a civil nature,
Yeah.
which have to be appropriately agitated by the agreed person before. We've said that already. Then Muller's para 48. This Arjun Singh Muller's decision is also,
Sessions also.
yes, it's also Sessions order, Muller.
Maybe you argued it on the other side in para 30.
I must have had a good case, Muller.
I'm saying, you're trying to correct all those errors.
I argue for Sharad Yadav in this case, for Sharad Yadav. Chotu Bhai was his president.
And it is rejected, sir. Our contention is rejected.
Yeah, contention, sir. Occasionally it is.
A lawyer never loses.
In support of their case, petitioner submitted that since the respondents failed to hold organizational elections, the office bearers ceased to exist. Well, that was rejected. Let's not leave that out.
It said both are equally guilty.
And said both are equally guilty. Then, Mullahs, we give Mullahs at page 18, we compare the power of the president because that's the other thing. The commission holds that the 1999 election is fine. I have demonstrated that the same extent of power but it's the same. And I've given Mullahs the relative provisions. So even on that count, Mullahs, the election commission is wrong. When, as I told your lordships, election commission knew where it had to reach. And then it devised a sort of a passage for itself to reach there, albeit a bit undemocratically.
There is no significant alteration in 2018. That is what precisely you.
That's right. Then refusal to apply the test of majority in the organizational election. He refuses to apply that test. And let us kindly see para 54 at page 20. 5 minutes, okay. And the note Sadiq Ali's judgment, para 26. As Congress is a democratic organization, the test of majority and numerical strength, in our opinion, was a very valuable and relevant test. Whatever might be the position in another system of government or organization, numbers have a relevance and importance in a democratic system of government or political setup, and it is neither possible nor permissible to lose sight of them. Indeed, it is the view of the majority which in the final analysis proves decisive in a democratic setup. On that point, we have no hesitation in holding that in the context of the facts and circumstances of the case, the test of majority and numerical strength was not only germane and relevant, but a very valuable test. In fact, the test of legislative majority is not even contemplated, Mullahs, in paragraph 15. As regards the organization wing, it is settled law that Commission considers the numerical majority in the apex representative bodies in the party constitution. This position is accepted by the Election Commission in the impugned judgment itself. However, the present case is a unique case where the Commission, whilst deciding a dispute under 15 between rival factions of a political party, has refused to consider the numerical majority in the apex representative bodies of the party organizations. Para 3 of the 103, the Commission considers the 2018 Constitution, relied on both sides, and identifies the Rashtriya Karkarani as the apex representative body in the organization wing. But then he says that it has only these 13 members, largely, and he says Pratinidhi Dava is largely appointed. Then at para 107, which I've read already, so Mullahs, I'll not trouble your lords. Now para 61. It is settled law that the test of majority is the most consistently applied test to decide disputes under para 15. Majority is determined both in respect of organizational wing and the legislative wing. The Commission never inquires into whether the apex bodies in the organizations are elected or appointed. Reference is invited to the following decisions. We give these decisions. Sadiq Ali, Mullahs, while deciding a dispute in para 15 between two factions of the Indian National Congress, this Honorable Court approved the test of majority and numerical strength and considered the majority of rival factions in both the legislative wing and the organizational wing. In Janata Dal dispute, Mullahs,
One of 94.
one of 94, which I've already read, I will not trouble your lordships with that. And then Chandrababu Naidu versus Lakshmi Parvati Commission applied the test of majority of both legislative and organizational. Arjun Singh Commission followed the law laid down by Sadiq Ali and determined numerical majority in the legislative as well as organizational wing. Then, brothers, all these judgments that I've given, I don't go take trouble of reading all of them. It's still too much for us. But I've given the path.
Cited well.
Yes, so we've given all that, brothers. And then brothers, at Commission's finding, this is at page 25. Brothers, I fail to understand. Brothers, supposing I am appointed, brothers, I have still the right to elect. So the Commission says because a large number of smaller office bearers are appointed by me, therefore I will not consider this constitution to be democratic at all. In the Pratinidhi Sabha, they have the right to elect, but merely because I appointed them doesn't mean that they would not exercise that right. So the very basis of that order is bad. So from any standpoint you look at, from any standpoint, it's an order which is outside of paragraph 15. It's an order which is in the teeth of what is required to be done under paragraph 15. It is an order which says that I will only recognize the legislative while the matter is pending for their disqualification. If that were to be decided, there would be no we would be in the legislative majority. If they were disqualified, we would be in the legislative majority. So, I almost concluded.
If you need 5 minutes.
Just 5 minutes more.
Topic at least.
Yes.
Page 25.
Page 25.
The way you want to say.
Yes.
You may sum up the way you want.
Yes.
5 minutes more we can say.
I'll continue disqualification on Tuesday. My lord knows that. I'm just finishing this. So, para 25, page 25, Commission's finding that the Shiv Sena Prathi is largely appointed. It doesn't detract from the fact that these appointed people will vote. There's no power of attorney given to the Paks Pramukh that he will vote according to what I decide. So that sort of, and then
2018 amendment is primarily to widen the structure of the organization.
That's correct. That's correct. Absolutely.
Probably this is what you want to communicate.
That's correct. 2 posts are added. Saman Vayak and Saman Sangat.
This amendment is not meant to reduce.
It's meant to enlarge.
Numbers of 99. It is only meant to widen it by adding some nominations or some appointments.
The point is, they said that since that time, the party activities extended to such a great extent and gone into rural areas, I need to actually add these numbers. But adding these numbers doesn't detract from the fact that they will have the right to vote.
Top rank is entirely elected.
And top rank is entirely. So, the decision-making bodies are elected. The administrative bodies and other bodies are executive. So if it's the treasurer, I don't have to elect him. So the whole reasoning of the Election Commission is contrary to well-settled principles and to the terms of the paragraph 15 itself. Then
Stable at page 26, Mr. Sibal.
Yes, page 26. Pratinidhi Sabha. This is Paks Pramukh, Rashtriya Karkarni, we've already shown to your lordships. Deputy leaders, numbers 1 to 3 are all elected. 33-21 in the deputy leaders, 13-9 and Paks Pramukh. Then members of the House elected, members of House of Parliament elected, secretaries, Sangathaks, Samanvayaks and Rajya Sampark Parmukhs appointed, Rajya Parmukh elected, Zilla Sampark Parmukh and Zilla Parmukh appointed. This is the layout, Mulaj. And the argument is because there are a large number of appointed people, I won't look at this constitution. Why? Because as if the appointed people will vote only according to what the leader says. Then Mulaj's determination that majority in the legislative wing is decisive in awarding the party symbol. There again, Mulaj. This is the table from the Election Commission. See the situation as at that time. Eknath Shinde had 40 out of 55 in the Legislative Assembly. Mulaj, I had 15 out of 55. So I was in minority. Then members of the Legislative Council, it has 0 out of 12. I had 12 out of 12. Members of Parliament, he had 13 out of 19, I had 4 out of 19. And members of Parliament in Rajya Sabha, he had 0 and I had 3.
I had total 34.
So I have a total of 34, mother.
It's 53.
He has 53.
Which 39 are disqualified.
Out of which, if 39 are disqualified, I am the majority. And on Tuesday, I'll show you why they should be disqualified, but they can't today, brothers, because there's another election. And Subhash Desai, brothers, said
Election Commission can't go by
Election Commission cannot go by, brothers, legislative majority. That directly said. So I'll take your lordships on Tuesday. Thank you. License.